Today on Don't Talk TV, in the wake of the recent decision on the Skelly case, I thought it was important to discuss what jurisdiction does the Superior Court of Ontario have to hear cases, and also talk about the independence of the judiciary in Canada. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So, as some viewers may know, just earlier this week, on June the 28th, 2021, was supposed to be day one of a 2-day hearing with respect to the case of Skelly, the owner of Adamson Barbecue in Toronto, who's become somewhat of a folk hero and a focal point among those who are opposed to the unprecedented health restrictions, the COVID-19 laws, and the so-called Reopening Ontario Act. So, when I first heard about this case, what I heard was that the Superior Court of Justice judge hearing the case essentially tossed it out, saying that she didn't have jurisdiction to hear the case. Now, when I first heard that, I thought, this is the craziest thing I've ever heard. This is the craziest thing I've heard since all the crazy things that I've seen starting in March of 2020. But looking into it, I think it's not all as seems on the surface. So I want to talk about that. I was going to talk a bit about Canada Day, previously known as Dominion Day, and still called that by some of us who are old-fashioned monarchists like myself. But given the uproar and given the potential consequences for the rule of law in Canada, I thought I really had to look into this. So to discuss this, we'll just look a little bit of brief history on the Adamson Barbecue / Skelly case. We'll look at the jurisdiction that the Ontario Superior Court of Justice has, and then we'll look at the news reports and what's being reported on this case. I would much rather have the actual judge's decision to look at and the pleadings that were filed by the various parties. I don't have access to that, at least not yet. It's hoped that that decision will be reported eventually, but for now we just have to go off the news reports. To give the background, let's actually look at the National Post article that I'm going to be relying on for what happened in court on Monday, the 28th of June. Here's the article from the National Post titled, "Barbecue Rebellion Gets Turned Away from Court, Delaying Face-Off Over COVID Lockdowns. An Ontario judge declined to hear a constitutional challenge from Skelly, the man who refused to close indoor dining at his restaurant, Adamson Barbecue." Now, before I get into the background of Mr. Skelly, I have to comment on this opening paragraph here. To the dismay of supporters of a high-profile COVID-19 scofflaw, an Ontario judge declined to hear a constitutional challenge of pandemic enforcement mounted by Skelly, who refused to close indoor dining at his Toronto barbecue restaurant during the lockdown. Now, the reason I have to go this is, look at the editorialization right here, calling him a scofflaw. This is something I have to comment on because we talk about freedom of the press and how important a free press is to democracy, but in my view, this is barely journalism. This is editorializing. It's taking a firm position and already setting up the reader with a negative impression of Mr. Skelly, presenting him as a scofflaw, not as a concerned citizen. Just to talk a bit about here's the background that's important, I think, here, where it says, in November 2020, Skelly's restaurant in West Toronto became a high-profile flashpoint when he defied orders to close indoor dining to help stop the spread of COVID-19. Again, we got the editorializing there. He didn't refuse to stop the spread of COVID-19. He's been very public that the reason he opened up his restaurant is because, in his view, shutting down restaurants when Costco and Walmart are all open didn't do anything to stop the spread. So anti-lockdown protesters clashed with police who arrived in large numbers to enforce compliance. The city sought a court order restraining Skelly and his company, Adamson Barbecue Limited, from contravening the Reopening Ontario Act, the province's regulations on what can and cannot be done in the fight against the virus that causes COVID-19. And that restraining order, opposed by Skelly, is what brought the parties to court Monday. But for Skelly, it was about far more than his ability to serve food without government permission. And as he here, we'll give him his quote here, My lawsuit has very little to do with my restaurant. It is a constitutional question of the Reopening Ontario Act and the evidence or lack thereof used to justify it, Skelly said in a written statement prior to the hearing start. So that gives you a bit of a nutshell what the case is about. I'm not going to dwell on the propaganda elements of the mainstream media reporting here. That's not the purpose of this video. I think I've already outlined my concerns on that. So what I heard about this case is the judge said she didn't have jurisdiction to rule on this, and the 2-day trial was shut down. So as I said in the preamble, my initial response is, this is the craziest thing I've ever heard. And let me show you why that's so crazy. Let's look here at the Superior Court of Justice, right on their website, talking about the jurisdiction of the court, says right here, quote, "The Superior Court of Justice in Ontario has inherent jurisdiction over criminal, civil, and family cases arising from Ontario's common law traditions. The court's inherent jurisdiction gives it authority to hear any matter that is not specifically assigned to another court level. The court also has authority over matters granted to it by federal and provincial statutes." That's why when I heard a Superior Court Justice saying, I don't have jurisdiction to hear a case, I thought that's absolute insanity. The Superior Court has inherent jurisdiction over any matter, right as their website says. I use their website for ease of reference. You can find that in case law. It's one of the most basic things I learned in law school. When I hear about a justice of the Superior Court of Justice saying she doesn't have jurisdiction, then I'm wondering, who has jurisdiction then, if that's her view? This, at first blush, seems like a complete breakdown of the rule of law in Canada, and a complete breakdown of the judicial oversight of government to make sure that legislation is in compliance with the Charter. Now again, I don't have the judge's actual decision, but if we go back to that National Post story, I start seeing some things that suggest this is actually a legitimate decision of the court. The judge isn't saying she doesn't have jurisdiction over the matter at all. She doesn't have jurisdiction because the proper pleadings weren't put before her, which some people may object, well, that's putting procedure over substance, but procedure is very important in criminal laws. And I always come back to, you want judges to enforce procedure on you so that they'll enforce it on the government, and that they'll enforce it on people who are trying to infringe your rights. Everyone should be bound by the same rules, and the rules should be followed by everyone. So let's take a look at a few things that jumped out at me from this article that make it seem like it's not exactly what it looks like at first blush, which is hardly surprising, because in my experience, the media is not very good at accurately reporting what's happening in courts. Any court case I've been involved in, I've found significant differences in the way it was reported in court to the way I perceived things happening in the actual courtroom. I go back to here where it says the restraining order is what brought the parties to court Monday. And this is key when we get to the judge's decision. So the Crown argued that there was no procedural basis to entertain Skelly's constitutional objections. He said that Skelly had not embarked on any court application claiming relief against the province. He was only contesting Ontario's motion against him in his restaurant. So just to try to translate that from legalese, what the Crown Attorney was saying is that they're only there to fight over whether the injunction should still be in place. Mr. Skelly and his lawyers had not placed a notice of constitutional question before the court. They hadn't brought an application asking the court to strike down the Reopening Ontario Act. So how can the court strike down the Reopening Ontario Act if they haven't even been asked to strike down the Reopening Ontario Act? Now, and I think this is a fair point made by the Crown Attorney as well. Green said Skelly has been represented by experienced lawyers. Their reply to the government's notice was signed by 4 lawyers, adding it's not as if it was an inmate appeal on a scribbled note from a self-represented litigant. So I think that's fair. Basically what the Crown Attorney is saying is that a self-represented individual who doesn't have access to legal counsel, you're going to give them more procedural leeway because they can't be expected to know all the ins and outs of the rules of procedure, which forms need to be filed, what legal write-ups have to be made. Whereas when one is being represented by a team of 4 experienced lawyers, they're expected to do things properly. people in support of Mr. Skelly may not like the result, I don't see anything offensive in what the Crown Attorney argued here. And if the Crown Attorney is accurate, that no notice of constitutional question was filed, I think the judge is 100% correct to say she doesn't have jurisdiction, because the thing that they want her to decide isn't even before her without that application being before the court. All court proceedings are initiated by paperwork, be it an indictment, an information alleging a crime, or a notice of application. Counsel for Mr. Skelly, Michael Swinwood, representing Skelly, replied that the constitutional element of Skelly's defense has been clear from the start. If the province objected to his constitutional questions, they should have asked a judge to strike them out of their reply to the court. And he noted that pretrial procedures, including judicial case management conferences and the examination of cross-examination of expert witnesses, went ahead, arguing the wider constitutional issues without any complaint or objection from the province. Now, this also is a fair point on the other hand. I think his counsel saying, look, no one's caught off guard by this. This has been clear, what we've been arguing from the start. And it seems like a little bit of dirty pool, or what's called sharp practice in the rules of professional conduct that lawyers are ethically not allowed to engage in, to remain quiet on this issue and wait to the day of trial, and now all of a sudden say, we're raising a point of jurisdiction, we don't have the notice of application. Although, again, that said, that notice of application needs to be there in order for the court to have something to rule on. So, although it's no doubt beyond clear from what was going on, constitutionality of the Reopening Ontario Act was an issue, you still need the originating documents to give the judge the jurisdiction to rule on it. You need to make the application for the judge in order to give you a ruling. Now, I don't know what happened. I don't understand how you can get through judicial pretrials and case management without this being brought up before. So that's a bit weird. But just to continue here, then we see that here's the judgment from the judge. Actually, the title is Justice, so the National Post has the terminology wrong. Justice Jasmine Akbarali of the Ontario Superior Court of Justice briefly adjourned court to deliberate before returning with her verdict. Quote, I regret to say I do not think I have the jurisdiction to proceed to deal with these issues on their merits today, quote, unquote, she said. Quote, I do not think the hearing has been constituted in such a way to give me that jurisdiction, and it is in nobody's interest to go ahead with the 2-day hearing that is easily vulnerable on appeal on the basis that I didn't have jurisdiction. And she said written reasons were to be issued later. I'm certainly waiting with bated breath for those reasons, and more will be made clear. But from this article, it sounds like the judge acted quite fairly and properly here, where she said, I'm not going to make a judgment when I don't have the proper application before me, because the Court of Appeal is just going to toss it right away. So really, what's the point in putting everyone through this time and effort for something that's just going to be appealed, and rightfully appealed? It doesn't appear that there's judicial corruption here in any way, and I see a lot of people making that accusation. In my view, that's totally unfair and inappropriate to be suggesting corruption in Canada's judiciary over this case. In my 16 years' experience as a lawyer, I have not seen evidence of corruption. In my view, Canada's judiciary is generally very fair. They are not corrupt. Yes, their paychecks are paid for by the state, but someone has to pay them. You're not going to have experienced lawyers and good judges be willing to judge cases for free. Someone has to pay them. And having the litigants paying them directly could have its own issues, because then you become like in third world countries, and I've met lawyers from there that have told me cases are decided by whoever has the most money to pay the judge. That's obviously not a workable situation either. So, in my view, the Canadian justice system is still functioning largely as it should. We may not always like the decisions that judges make, but that's what appeal courts are for. That's what the Supreme Court of Canada is for, to review lower courts' decisions. And in this particular case, so far, I'm not seeing any evidence of corruption or anything untoward on the part of the judge. What it appears is that counsel for Mr. Skelly, for whatever reason, and I mean, I don't know, I'm not going to sit here and Monday morning quarterback their decisions. I'm sure they had good reasons to do what they did, but it appears that the constitutional application that needed to be before the court wasn't before the court, therefore the judge had nothing to rule on. And she was actually giving them a chance to file the proper application and then have this matter heard properly without being vulnerable to being summarily tossed out by a court of appeal. course, this video is not legal advice. If you need legal advice, contact a lawyer. You can call myself or another lawyer. My 1-855 number and my website are listed below. And if you have any ideas for topics for me to cover on the show, please leave a comment in the comment section below or send me an email to the email address listed. And if you found this video at all helpful, informative, or interesting, please consider liking, sharing, subscribing, and following me on social media.